Greetings to all watching the video. I welcome you all to another episode of Convo with Apricus. Friends, our topic of discussion today is RERA and its impact. And to throw light on this topic, we have our very special guest, Dr. Shalini Rohilla Panigrahi. Dr. Panigrahi is currently working as Assistant General Manager Law with HUDCO, Housing and Urban Development Corporation, which is a premier techno-financing public sector enterprise in the field of housing and infrastructure development in India. She has more than 15 years of experience in this field. She has strong academic background and she pursued her doctorate in the field of housing with the topic Right to Housing Towards Fundamental Right Responsibility of State to Provide Adequate Housing in India. Welcome, ma'am. Welcome to Convo with Apricus. We will start the discussion now. Ma'am, please enlighten the audience about what is RERA, what are the objectives of introducing RERA, and what are the salient features of this act.
Thank you, Reshu, for giving me this opportunity to present a series on RERA. So let me start by sharing the screen, if you allow me. Okay. Are you able to see the screen?
Yes, ma'am.
Okay. So we will be discussing about the legal aspects of financing affordable housing, and more particularly with the RERA in mind. RERA is Real Estate Housing and Regulation and Development Act, which came in 2016. Move forward. Yes. I'll share it. Okay. Yeah. Now, there is always a question asked why this act was required, why RERA was required. The home buyers, we have seen so many flats coming up, and home buyers today they are like running after the flats. They have already paid the installments, still they are not getting their dream house. So what was the problem? This problem was understood by our leaders, and this things were discussed in the parliament. And after this discussion, it was realized that this real estate and housing sector were highly unregulated, and there was lack of transparency, and the builders were not giving the proper information, and there was no remedy left to the buyers. They have to be at the mercy of the builders. So after a lot of discussion with the stakeholders, it was seen that in 2016, the act in the parliament was introduced, which seeks to protect the home buyers as well as to boost the investment in the real estate industry. So a bill was passed in Rajya Sabha in the year 2016, and this act fully came into the force on 1st of May 2017. Now let us see what are the salient features of this act. What was the purpose behind that? This act was to establish a real estate authority, because there was no authority for the regulation of this sector as such. So some authority has to be created where the home buyers can lead their grievances. There was no projects came up one after one, but there was no transparency. The home buyers were not aware what was the project, how was the land acquired, on what land that project was coming up, was the title clear or not? Are they buying the house on a land which was already under litigation? They were not aware of these things. Then there was a thing that to protect the interest of consumers in the real estate and to establish an educating mechanism for speedy disposal. Because if the buyers were having any problem, they used to go to the consumer courts, and you know the consumer courts, how they are working. So years and years, these cases were lingering on. So a quick redressal mechanism was required. Then the builder were not giving proper information. So that led to there was no transparency in the system. Now, what the salient features of this act are to establish an authority, and in particular, state as well as a government body to be approached for redressal of the grievances against any builder. This authority has to be established in every state. And there was a central law, but the state were given the liberty that they can make an act according to their conveniences. This law vests the authority on the real estate regulator to govern both residential as well as commercial real estate transaction. Not only residential, but they were covering commercial as well. Now, this law makes it mandatory. Earlier, the developers were not giving information about the layout plans, their approvals, what was the land title status, what was the project, when the project will be completed. So they were not giving any information. Now, this act is making it mandatory. So we have to get every project registered with RERA. And if registration means you have to give all information, you have to post all information. If you are not posting all information, your project will not be approved. The current practice of the selling on the basis of ambiguous sale deeds up to the area of the real estate project will come to the stop, as this law makes it illegal. The current practice was before this act came into the force. They were billing on the builders were making unambiguous practices. The super built up area was not defined for the real estate project. The maximum jail term for the developer who is violating is up to 3 years. Earlier, there was no such penal provisions. And if the project is delayed, then the developer does not suffer in any way. Now the law is ensuring that if any delay is there, or if any defect is there in the building, then they have to pay. They have to be penalized for that. The developers cannot make any changes to the plan that has been sold. If the plan has been approved and the buyer are aware of this plan, particular plan, the developer cannot change that plan according to his whims and fancies. These are the restrictions which have been laid down by RERA. This act puts an end to the common and unpopular practice by developers to increase the cost of project, because when they are launching the project, they are putting some price, and when they are selling it, they are putting some other price. So this will put an end, because if anything is registered and it is coming on the website, you cannot change the price afterwards. And lastly, every project which is more than 500 square meters or more than 8 apartments will have to be registered with RERA. Earlier, it was not so. No registration process was there. Now, even the 8, if it is an 8 apartment structure, you have to get it registered with RERA. Then one very important feature is that this law is mandating that every builder has to keep 70% of the collection from every project in a separate bank account, so that that money is not siphoned off. They have to keep it's like escrow account, which they have to, whatever the money is coming from the these home buyers, they have that amount has to be kept in a separate account, which will be used for that project only and not for any other purpose. Now, we have seen in so many cases in Noida where the project has started, but it is not completed. Why? Because that money is siphoned off in some other projects. So the home buyers are just waiting for their dream house. So this act is taking care of these things. It covers all private and public which develop the real estate project for sale to the general public. Thus, development authorities and even housing boards are covered under this act. They are also not left free. Now, this act is majorly covering these 4 important topics: registration, buyer's protection, establishment of an authority, and judicial mechanism. The whole of the RERA is covered under these broad objectives: registration, protection of buyers, establishment of an authority, which was earlier missing, and what is a judicial mechanism, how we can approach if we are aggrieved. Now, let us go one by one. Who is liable to get registration under RERA? This is covered under section 3 to 9 of RERA Act. As I have already told, all commercial and residential. This means that not even residential, all commercial also, both will be covered. Real estate projects, which whether a land is 500 square meters or more than 8 apartments or more, they have to mandatorily register with RERA for launching that project. If they are not registered, that project is illegal, and you can sue that builder on the very face of it. For the ongoing projects, the projects which were ongoing before this coming of RERA, which have not received completion certificate on the date of commencement of the act, will have to seek, they got a time for 3 months. But whatever the new projects are coming, they will be given 30 days for the registration. Now, everything cannot be done by these authorities. So some real estate agents are also introduced in this act. They will facilitate. They are like just property builders. They are property agents. So these agents are facilitating selling and buying of properties. Even they have to get registered. The proper information should be there on the website about them. These agents are given a registration number so that we can track them. At every property which is registered with RERA, a common man can go in the RERA website and they can seek all information about the project, about the builder, about their land, how the land has been acquired. Everything is available. Only then we can move ahead for buying that property. Earlier, this information was not there. So this act has been a boon for buyers. Now, what is the process of registration? The applicant has to file an application for registration. The builder, applicant is the builder, with RERA in the prescribed form. Application has to be approved. It will be either approved or rejected, because if the papers are not complete, if the title is not clear, that will be rejected. But a time period is given so that the things don't get linger on. Even the builders, some of the builders are, not all the builders are fake. Some of them are genuine also. So this act is both for buyers and builders. Earlier, it was thought that this act is only for the buyers and not for the builders. But no, they are also given equal benefits if they are fair enough. On successful registration, when the projects get registered, the promoter will be provided with the registration number, as that will get the number. Similarly, the promoter of the project will get a registration number, login ID, and password for the applicants to fill up the essential details on the website of RERA. And if they fail to register, then there is a penalty up to 10% of the project cost or 3 years imprisonment. So there penal provisions have been introduced. Now this is this flow chart I have made just to make it very clear how the things will be going. No project or promotions advertisement are permitted before registration. Earlier, this malpractice was done by the promoters, that they used to promote the project without taking any approvals, without getting all the clearances. They used to promote and lure the home buyers. They used to just pay the money, and afterwards it was known that this project was faulty. So the brief details of what all details are required for registration. The details are like name, registered address, type of enterprise, then copy of commencement certificate, sanction plan, layout, location of that project, clearly demarcation. The land which is on which the project has to be made, that should be clearly demarcated. Pro forma of allotment letter, agreement to sale, number, type, carpet area of the apartment, because whatever carpet area they are providing, that should be known to the buyers, not some other. Details of the agents who are registered with RERA for this particular project. Declaration supported by an affidavit signed by the promoter. This is very important so that he doesn't back out. Now, registration, declaration by the developer, restriction on the use of funds. This is very important. What are the mandate of registration? Land title to the land proposed to be developed. That land should be free from all encumbrances, because whenever we are buying a property, we are seeing that this land is free from encumbrance, this flat is free from encumbrance. So whenever we are going for buying of property, we have to see all these. By way of registration, all these details have to be uploaded on the website. So whatever projects are registered with RERA, they have to make it mandatory. 70% of the amounts that has been acquired from the home buyers has to be kept in a separate account in a scheduled bank, and that will be used only for that project. Developer mandated to develop the project from the allottees in a separate bank account so that he cannot withdraw it, and there is an audit for these. There is a provision for audit also, where these accounts, where this money has been used. So there is a proper audit process also. Now, how that registration can be revoked? Why the registration will be revoked? If the promoter is defaulting any of the requirements, that registration will be revoked, that will be cancelled. If he is violating any of the terms and conditions of approval, if he is involved in unfair practices, then he will be given an opportunity of hearing of 30 days. And if he is proving it right, then that registration can be reverted back also. Now, what are the consequences of this revocation of registration? If his registration has been revoked, then he will be debarred from accessing the website. He will be listed in the developer as defaulters. You can see in the defaulter list that this developer has done something wrong. So please don't go for this developer. Inform RERA to other state also, not only this state. So suppose he does a malpractice in UP and he starts other project in Delhi. So is it possible? No. All RERAs are connected. They will immediately, the information will go in the other states. Hand over the development to the allottees or the competent authorities upon the consultation with the project will be handed over to the allottees on his failure to do so. Now, registration has a time limit for the as I already told, for the ongoing project, it is 3 months. Mandatory, they have to get registered. And for the new project, if the project is registered today, they have to get it registered within a period of 30 days. But exceptions are there. If the area is less than 500 meters, that has not to be registered with RERA. And if the apartment is less than 8. So this is a type of loophole in this act. If suppose the builder or the promoter divides his project into less than 8 apartments, so he does not require registration. So this is a type of loophole. In case of renovation, repair, redevelopment, registration is not required. Now, revocation. Revocation of the registration, it can be done on a complaint of home buyer, or even the suo motu, the RERA authority can take an act. This slide is giving the complete, whatever I have discussed, it's just a gist. The consequence of debar of registration is debar the promoter from accessing the website. He will be in the list of defaulters. His photograph will be displaced. He will be like, suppose someone has done a bank fraud. So his name come in the civil authorities. In the similar way, this promoter will be blacklisted. His bank account will be seized. So stringent provisions are there under this act. Now this act was basically, when a lot of discussions were going on, people were saying that this act is for buyers. Yes, this act is for buyers, but even the promoters are getting benefit. Yeah, because this act has created confidence in the buyers. And if the buyers are confident, they will go for buying the property. So this is promoting real estate. The basic idea was that the act prohibits unaccounted money from being pumped into the sector. As of now, 70% has to be, as I told you, 70% of the money which is coming from the home buyers has to go in a separate account, which will be used specially for this project. The major benefit for consumer included is that builders will have to quote price based on carpet area and not super built area. Carpet area has been clearly defined in the act to include kitchen, toilet. So the buyer cannot say that this is not included in the carpet area. Carpet area means the net usable floor of the apartment, excluding the area of external areas. So in the first time, this carpet area has been defined so that the buyer, this promoter cannot play with the money of the buyer. They have to define this carpet area. This particular area will be provided to you. Now, what are the duties and promoters? They are given under section 11 to 18 of RERA. He has to mandatorily register, that is his duty. He has to tell all things about the apartment, when it was booked, when the approval was taken. He has to inform the allottees about the sanction plan, layout plan, stage-wise schedule of the completion. He has to take the payments as per the schedule only. Now, duties, other duties, general duties are, he is responsible for all the obligation, responsibilities, and functions of this act. He has to obtain a leasehold certificate, completion and occupancy certificate. He has to provide all essential services for the maintenance by the association of allottees. He has to execute a conveyance deed. After executing the agreement of sale, not to mortgage. He should not mortgage that apartment to someone another. Cancellation of allotment only in terms of agreement to sale. These are the general duties of the buyers. Then other duties are, he has to be responsible for whatever advertisement he is announcing. Whatever he's specifying in the prospectus, that should be he should not quote a false statement. Prohibition from taking more than 10% of the cost of apartment. He has to take just the 10% in the initial payments. He cannot ask more than that. Other functions and duties are, he cannot make any structural alteration or addition to the sanctioned plan. If some changes has to be done, he has to take the written consent of 2/3 of the allottees. So this is another protection for the buyers. He cannot change any major structural changes, he cannot take out. Minor additions can be done due to some architectural or structural reasons. But if some major structural change has to be done, he has to take a written consent of 2/3 of the allottees. Transfer assignment of majority rights and liabilities in respect of projects to third party would require written consent. No extension of time to the intending promoter in order to comply. There will be no time extension. Whatever time limit is given in the RERA, he has to comply with that. There are no extensions. Earlier, there was no such guidelines. Functions, and he has to get that property insured, payment of interest to the allottees in case of default. He has to hand over any failure on the part of developer to hand over the possession of property in accordance with the agreement to sale would empower the allottees to withdraw the project, and they can even demand refund. So whatever the promoter has promised in his initial advertisement, he's bound by his words. Claim of compensation, if there is any defective title, there is even a compensation provision also. Even if there are some structural defects or any other defect in workmanship quality, if he has promised some tiles proper, suppose he has promised that there will be tiles in this area, and if he's not giving any tiles, that is a structural defect. So he has to compensate for that. And if some defect is treatable, he will do it. He has to do it under this act. Now, these were earlier we discussed about the duties of buyers. Now we are talking about the rights of buyers. What are the buyers' rights? They can obtain information about the sanction plan. They have every right to entitled to know about the stage-wise schedule of completion. They can claim the possession of apartment as per the time period. Whenever the date is coming for possession, they have the right to claim possession. The promoter cannot say that we will not give you possession. It is still for completion. But if the time period has come, he has to give the possession. Claim refund if he is not providing possession. Claiming of refund is a very important right of buyer. So these provisions have added strength to the buyer's right for home. So this act is a step towards the right to housing in reality. Earlier, the right to housing is not provided under the Constitution of India. There is no guaranteed right as such. But these acts, these positive steps are, in a way, they are providing a right to housing only. Obligation of buyers. Now, with rights comes a duty. In jurisprudence, there is a principle. Whenever there is a right, there is a duty also. So buyers have also some duties. They have to make the payments in a time specified. It is not that they can shirk from their responsibility. They have to make the payments in time. If there are some delayed payments, they have to pay the interest also. Participation in the association or society or cooperative society. They should take possession. If the flat is complete, they are bound to take the possession. Take possession within 2 months of completion of occupancy certificate. They should participate towards registration of conveyance deed. If they are not coming for registration, there is a penal provision for them also. So they should come for registration. Now, after seeing the rights and duties of buyers and promoters, very important provision in the act is for authority, real estate regulatory authority. This is one of the salient feature of the act also, that this act provides for a creation of an authority who will take care of all these. The implementation of this act is taken up by these authorities. If these authorities are not there, then this act is like useless. Now these authorities have come up in almost every state of India. Establishment of state level authorities to regulate the transactions both in commercial as well as residential. RERA is ensuring timely completion and handover of the projects. And if there are complaints against the builders, they are heard by these authorities and there is a time disposal for them. 60 days time has been given to the authorities. And if some authority is also not giving proper orders, there is an appellate tribunals for hearing these. If there are some orders passed by the RERA, which is not acceptable, there are appellate tribunals and they also have 60 days time to hear those matters. It is not that they will linger on like years on years. There are time limits for every hearings. Now, real estate, what is RERA? RERA Act is providing for establishment of RERA in all states to regulate the projects being developed in that state, which shall have the powers of a civil code. There are no guidelines, but they will follow all the provisions of civil code. Like there will be hearings, there will be evidence, everything will be there according to the civil code. All civil code procedure will be followed there. RERA to be set up by the state government. It is up to the state government. It's a prerogative of the state government to develop RERA so that the Central Act RERA, which was made with the objective of transparency, of creation of authorities, of hearing of the promoters, and realizing the rights of buyers, they have to come up with the authorities. And in now almost in every state, this authority has come up. Until the establishment of RERA, the state government shall designate if suppose the RERA is not in a particular state. So then what happens? And if some project is coming up, some problems are coming up, so some other authority is given the power of RERA until that RERA has come up in that particular state. In some RERA would act as a nodal agency to coordinate the efforts regarding the development of this sector. And what it will do? It will also advise. It has an advisory role also to the state government, because state government is not equipped. RERA authority has officials which are specially equipped with the this real estate powers. They have to ensure the growth and promotion of the transparent and efficient and competitive real estate sector. Because earlier there was monopoly of one buyer, but now after introduction of the registration process and everything, transparency has come in this field. And one of the functions of RERA is to recommend to the local authorities and the state government for the creation of single window clearance. This is very important. We have to understand that why this single window is required. Earlier, for every approval, the promoter has to go to different authorities, and to get his work faster, they used to pay bribes and everything. So by creation of this single window system, for the approval of the project, this has introduced transparency, because one of the salient features of this act is to introduce transparency. So how the transparency will be there? If a single window clearance system is there, and that too in a time-bound manner. The authorities have to give the clearances in a time-bound manner, and that procedure should be followed. There should be a set procedure, and if the promoter is providing all those things, they have to be given a clearance. This act does not contain concrete steps to address this problem, because there is no single window system for project approval as such. This is the need of the hour. Even this act is lacking in various things, like single window clearance is still not in place. So even if the act is there, it has to be dynamic. There should be a provision for amendment. There is amendment procedure also. If some suggestions are given, they have to be introduced. Like I told you, there were loopholes in this act. If the builder bifurcates his project in less than 8 apartments, there is no requirement of registration. So he can take benefit of this loophole. Now, what are the functions and power of RERA authority? Functions are given under section 34 and powers are given under section 35 to 38. What are the functions? Registration and regulation of the projects, maintenance of database on the website for public viewing, so that even a common man can view the website and they can know about the various projects which are going on, what all approvals they have taken, if they are fully covered under this, if they have got registration, if they have complied with all the regulations and other obligations. Powers, this RERA authority can suo moto take up the problem. If suppose they read in a newspaper that this builder has done something wrong, even without a complaint of buyer, they can suo moto take action. Like courts can suo moto take an action. They can issue interim orders. Suppose there are 30 days time for the disposal. No, they can pass interim orders within a day or two also. So this has made a speedy recovery. Has the power to impose penalty in regard to contraventions of the obligations which are cast on developers, allottees, and the real estate agents. But still practical difficulties are being faced, even though powers are given, even though so many sections giving power to authority, but still we hear that this authority is not working properly. This authority is not properly working. In the upcoming series, we will be dealing with the authorities' power, how they are working. Some of the authorities like Mumbai Authority, Mumbai RERA is coming up really well. And there are so many orders, so many good judgments by them. We will discuss in the upcoming series. Now, judicial mechanism, as we can see in this slide is a very self-explanatory slide. How we can go with, first of all, we will go in RERA. If the authority is not giving proper orders, we can go to the appellate tribunal, RERA appellate tribunal. And if they are still aggrieved, then where they can go? To the High Court. And if they are not satisfied with High Court, then they can go to the appellate court. But things get settled before that only. So this is a judicial mechanism. Now, section 52 to 72 of the Act is talking about the defaults and the penalties. This is very important because this Act is providing penal provisions for the promoters who are faulty. What type of offense is given in this? I have explained in a form of tabular format, so it's become easy. Nature of offense, like if they are advertising, marketing without registration with RERA. This is very important, without registration with RERA. Registration is the key. If they are advertising without registration, what is the penalty? Up to 10% of the project cost. And what is the prosecution? 3 years fine. So these penal provisions is a deterrence for them. Sorry. Second is failure to obtain registration or fails to comply with the function as prescribed. The penalty is 10,000 for every day during which the default continues. So this default keeps on accumulating, which may extend to even 5%. So these penal provisions have to be taken care of by the promoter. They have to get it registered. Now they know that without registration, they cannot start the project. Then other provisions are there. Failure to comply with the orders. If some RERA authority has passed an order, and if they fail to comply with the order, the penalty is for per day default is there, and which accumulates again 5% of the estimated cost of the project. If they fail to comply with the orders of decisions of appellate tribunal, penalty for per day of the default, which can accumulate to 10%, and even imprisonment. So they have to mind their things now. If they contravene any other provision other than the listed above, then extending up to 5%. All those provisions which are given in the Act, I have summed up in a form of a tabular format so that our audience can understand it. Now, as we conclude, let us know what are the hits and what are the misses of this Act. Hits are that increased assertion on the timely completion, because whenever I am saying that transparency, what is transparency? If they have said 60 days, if I will complete the project in 2 years, so they have to mandatorily complete it in 2 years. Not that they keep on lingering like 7 years, 8 years. This causes frustration in the home buyers. A step towards safeguarding investment, because whatever we are investing in these projects, it's our hard-earned money. And if that goes in vain, so it is really very bad for the poor people who are like saving their money for these for a home which they want to buy. Increase in the quality of construction, because if any structural defect is there, they have to pay for it. So this is increasing the quality of construction also. Balanced builder-buyer agreement. The agreements are coming up in the website, so they cannot be single-sided. They have to be, it cannot be one-sided agreements. So that agreement has to be, there should be balance in that agreement. What are the misses? Timelines of approvals are not given. How much timeline that authority will take. Any delay in approvals from the authority could impact buyer as well. So this timeline is very important. There should be a single window clearance, and there should be timeline for all the approvals so that the projects don't get linger on. The bill may lead to slightly higher prices due to the reduced competition, because people are now, the builders are not going for the projects. Most of them have changed their profession because there are so many approvals, and also that has led to less competition. And if there is less of competition, the prices will really shoot up. Other hits are there. Faster dispute mechanism, because there are RERA authority and there 30 days they have to dispose it of. So this is providing for a speedy mechanism. Sale on the carpet areas has improved transparency, because earlier they were not providing on carpet area. Now after the defining of carpet area in the RERA Act, they are providing carpet area to the buyers. This has increased regulated broker environment and greater visibility in the developer's delivery track record. If suppose one builder is delivering in a timely manner, he will be hit there. He will be like, everyone will go for that project. Misses are there. New projects launches will become slow as developers are not able to launch without obtaining approvals, which are taking 2 to 3 years at the least. Other hits are there. Increased scope of eliminating casual operators, leading to the better organization of the sector. Minimum standard of governance and accountability have now been set to an extent, and there is a potential for driving standardization. Greater visibility in the developers' delivery performance, higher investment in this sector. These are the hits. Misses, on the other hand, are no provision to rationalize the number of approvals. Again, that approval is a very big hitch. Increased reliance on external capital to achieve high growth. There is a possible impact on joint venture arrangements and potential delay in the cash flow relation from the projects. If we overanalyze it, it can be briefed as real estate industry was already feeling the liquidity crunch. It is likely that with this regulatory burden, this compliance, and if that compliance, this will increase further. So real estate authorities taking a toll. This restricted use of 70%, well-intentioned and may result beneficial to home buyers. This 70% is a very important provision for the home buyers, because that dedicated amount will go for the buyer's project only. That the project, they will use it for the project only. They cannot siphon off the funds. Then dispute settlement mechanism has come in place. So the consumer courts are less burdened now, because all these complaints are going in RERA and they are settled in 30 to 60 days time. I am not saying about all RERAs, but 5 to 6 states RERA are working very, very smoothly, and they have given very good orders for the benefit of home buyers. So this is a step towards the right to housing. This could definitely revitalize consumer confidence in the oversupplied and overpriced market. So if we want a dream home, we have to see that this legislation was thereafter called an angel legislation for the buyers who was suffering on the hands of these promoters. Now these promoters cannot play with the money of buyers. They have to make an agreement for the sale compulsory registrable. That agreement to sale has to be get registrable. Indian Registration Act does not provide for compulsory registration, but still if we register, and it's safe for us all. It seems to penalize the developer, but at the same time does not provide any relief for the end user. Pre-launch sale of the project will now be a history. Bad news for speculators. Good news for, it is very important, because earlier they used to launch, they used to mislead by their false advertisement that we will complete in 2 years, we will complete in 3 years, but now they cannot make such advertisements which are not true. Supreme Court is now taking tough stands to give home buyer. We have already seen in Amarpali, JP case, which we will discuss in our next series, all these cases which have helped the realization of these rights, because act is there, but still judiciary has an important role to play in making this act a true act. So these are just the updates that 26 states and union territories have already notified the rules. 14 states have made the web portals. 6 states and union territories have established permanent RERA, while 23 states have been able to establish interim RERA. Gujarat, permanent appellate tribunal has also come up. 10 other states have made interim appellate tribunals. In other series, we will discuss the latest updations on this. Poor implementation of RERA has an adverse effect. So these authorities, if they are not coming up, this act will fall down. So the authorities have to come up and they have to work in a proper manner. So thank you for hearing me on RERA. And I hope you have got a fair idea on the
Thank you, ma'am. Thank you so much. You took time from your busy schedule and came here for the discussion in Convo with Apricus and explained the topic in such a lucid manner. You have given such a detailed explanation of the RERA Act, the objectives, the features, and how could we deal with the act. I hope the audience will get benefited from this series. Thank you, ma'am. Thank you so much.